gotta stay out of my head. Stuck between my rights and my wrongs. Second guessing what I'm doing. Like, am I really there for my boy? Not enough, but if I'm paying child support, do the making for time that I've lost. Whole time paying this court system. Can't even call my little man a game system, cause my checks be short. And if your bag too short, well, you had to miss a month. Slipping up, I gotta pick it up. Grind limitless, but it got your folks like, yeah, I hope you don't get caught. Like I missed them payments on purpose. Cause you see I fail and I'm hurting. Ain't had no job, so no working. Or the job I work is not working.
Shalom, this is your Ark. Yah is magnified. Coming back with another informative video. I titled this video, Status Conference and Voluntary Settlement Conference. But before I tackle this subject, as always, I must state for the record, I'm not a lawyer, I do not practice law, and I do not pretend to. All my videos are for informational and educational purposes only. They're all facts and all truth. Nothing more, nothing less. So with that being said, guys, let's get to it. Okay, so now, as you all know, man, before I go over this document, I have to state this. But there's a lot of propaganda going on in the public, man, you know, dealing with the death and the riots and everything else, man. All my people, y'all just need to stay focused, man, and understand, especially my Hebrew Israelite brothers, man. We know the scriptures and we know what the Most High Yah said, okay? We know we don't need to go out here and protest and get involved with this stuff that's going on. Why? Because we know the Most High will fight our battles, okay? Like the Most High led us out of the first Egyptian captivity, He will lead us out the second Egyptian captivity, as it's stated in the scriptures, okay? The Most High Yah, He fights our battles. There's no need for us to go out here and protest and do a bunch of this nonsense that's going on. You know, rioting, looting, and this doing a bunch of nonsense, guys. You know, we must stay focused. Get back to our Creator before you come back down and get back with us and get us up out of this situation. He's the only person that can get us out of the situation. He put us in this situation and get us out of this situation. It's just that simple. Okay? It is all done for disobedience, man. We need to get back to being obedient, keeping the laws and statutes, commandments of the Most High Yah, and everything will be alright. But until then and only then, okay? We must get our minds right, people. Alright? But now, most likely I will make a video going more in detail about that as well. But right now, let's go over this document that I have on the screen, okay? So we get better understanding of what's going on. So now, as you all can see at the top of the screen, it states what? Superior Court of California for the County of Orange, the minute order, okay? This minute order was filed on, or entered on, or written up on, should I say, April 7th, 2020, okay? 2 months ago. My Ark just receiving this, though, but let's continue. It states Judge/Commissioner, right? With her name. We all see her name is Nancy, but let's continue. The department I crossed out at 8 a.m., okay? The clerk name was there, right? But it states the bailiff, not present, okay? The reporter, not present, right? So that means if the bailiff wasn't present, the reporter wasn't present. Most likely no one was present at this minute order. But let's continue. It states what? Case type, child support. So you all can see this is in fact a child support case. Case number I crossed out. Then it states case name, County of Orange versus my Ark. We're going to call him what? JR or Junior. Okay? Appearances, none. Meaning no one was there. Why is that? Let's stroll up. Okay, as you all can see, no one was there because this was done when? It was done off the record. Okay? This whole thing, this whole document is off the record, okay? They want to settle this conference. They want to settle, or they want to have a voluntary settlement conference and a status conference off the record, okay? But let's continue, because I tell you all, man, once we start finding these documents, start applying pressure, start fighting back, you know, then you all will start receiving results, and you'll see how they changing up. And now, you know, they want to speak with him off the record, okay? But let's continue. It states, due to the emergency court closure and pursuant to administrative order number blank issued by presiding Judge Kirk Nukamura on March 23, 2020, suspending all non-emergency family law trials, hearings, and proceedings through June 1st, 2020, and requiring that all such matters be set for a status conference to be heard after June 1st, 2020. Right? But let's continue. The court makes a finding of good cause and orders the current hearing set for May blank 2020 in the above entitled matter is trialed for July blank 2020 and set for a status conference / voluntary settlement conference. Okay? So what they want to do, they want to have a status conference. A status conference mainly deals with what? A status conference mainly deals with the status of the case. Okay? Are they going to proceed forward? Do they want to proceed forward, or do they want to what? Voluntarily settle. Okay? That's what this conference is going to be about. Okay? But let's continue. But not only is it going to be about the status of the case, we're going to also switch it to the status of what? The party involved. Okay? But let's continue. It states, no evidentiary hearing will take place at the status conference / voluntary settlement conference. Pending the status conference / voluntary settlement conference, all prior orders issued, if any, remains in full force and effect. But let's continue. In addition, unless a restraining order is in effect prohibiting contact between the parties are hereby ordered within 15 days of the status conference / voluntary settlement conference to meet and confer in good faith via telephone, email, text, and other suitable video or audio means to discuss and resolve, if possible, the issues pending in the request for order. Okay? So who filed the request for order? The petitioner, which was the County of Orange. They filed a request for order. We sent a rebuttal to the request for order. So now they want us to do what? Have a status conference / voluntary settlement conference. Why? Because we rebutted all the presumptions on it for the record. So now they want to keep this off what? Off the record. Okay? As it states right here. Off the record. Okay, guys? So, as you all can see at the bottom, it states what? The trial states trial. The court orders this matter trial to July blank 2020 at 8 a.m. in Department blank. Then it states court orders this matter set for conference / status at 8 a.m. on July blank 2020 in Department blank. You see? And at the bottom it states minute order, crossed out the case, then it says what? Department of Child Support Services shall what? Give notice. So the Department of Child Support now have to give notice. But not only that, they have to prove what we asked them to. Okay? So, like I stated before, you all got to be diligent. Got to be willing to fight this fight, man. Like I stated before, it's not an easy fight, but it's a fight worth fighting, especially when you win. Okay? But that's all I'm going to do for today. But before I leave, I'm going to leave you all with this video coming up next that further explains the voluntary settlement conference. All right? So again, you all be blessed. Check out the video after this. Like, share, and subscribe. If you all need my help again, hit me up in my email at y'allsmagnified@gmail.com. And I repeat this again. Do not let anyone deceive you all to get you all riled up off your emotions to get you in a lot of trouble, okay? Understand that the Most High, He will fight our battles, okay? So now, with that being said, let's go to the video. Peace.
Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to explain pretrial settlement conferences. So a pretrial settlement conference is a meeting between the judge and the attorney for each party and the parties themselves for the purpose of settling a case prior to going to trial so that the parties don't have to bear the expense of a trial. The conference usually occurs after all discovery has been conducted. So it's usually once all the facts are on the table, depositions have happened, right before trial happens. But a pretrial settlement conference can occur at any time in the case. The judge can order it very early in the case, or the parties can request it and agree to conduct one very early in the case if it seems like the type of case that should settle early. So at any time that the parties think a facilitation of settlement would be helpful, the parties can have a pretrial settlement conference. And it doesn't have to happen only once in the case. It can happen multiple times if the parties think it will be fruitful. So let's talk about what to expect from a pretrial settlement conference. Again, these usually occur in the courthouse, and the negotiations happen in the judge's chambers. Usually all the parties will show up and wait in the courtroom, and then the judge will call each attorney back separately, sometimes with their client with them too. And the judge and the attorney and the client will all go back to the judge's chambers while the other side waits back in the courtroom. And the judge will basically hear the attorney's statement of the case, their theory of the case, why they think they have a good case, and what their settlement position is, what they'd be willing to offer or accept in settlement. So the judge will do this with both parties, and then after that, the judge will start working on each party or attorney individually. And usually this is with the parties in the room, because what the judge will do is basically say, I've heard both sides of the case. I've heard what everyone's settlement position is. Here's all the weaknesses in your case and why it's risky for you to go to trial in particular. And here's what a reasonable settlement would be for you. Can we get you to come closer to this reasonable settlement amount? So hearing the weaknesses of your case from the judge often spurs parties to be more interested in settling. And the judge is never going to tell someone, hey, you've got a slam dunk case, you should definitely go to trial, because the purpose of a pretrial settlement conference is to get the case to settle. The judge wants the case off his or her docket and not clogging up his or her schedule. The parties should want to settle, because if they can reach a settlement that's generally favorable to everybody involved, then they won't have to bear the expense of litigation and attorney's fees. So why are pretrial settlement conferences helpful in settling a case? The reason these work so effectively, one, is real-time communication between the parties. When you're not in the same room together or the same physical location, you are playing a four-way game of telephone when doing settlement negotiations. The party has to tell their attorney what their settlement position is. The attorney relays that to the other attorney, who relays it back to the other party, and then it goes back across the chain. And you can wait a week or two before getting a response to a settlement offer. So it's hard to get really creative. Sometimes it's not just dollar amounts that we're talking about for settlement. Sometimes it is finding creative solutions to problems. And it's hard to do that when the parties aren't all communicating in real time. The second reason that it's helpful is that for many people, they just want to have a chance to be heard by the judge. They have a grievance, they want it heard, and they can tell the judge their side of the story here. And then the judge can tell them, why that is not worth going to trial over. But sometimes getting heard by the judge is enough to make them feel vindicated and make them more reasonable about settlement. A third reason that this is really important, and this is probably the most effective reason, is that for parties who are being stubborn about settlement, and this is not usually the case for insurance companies or more sophisticated parties, but for individual plaintiffs and defendants, hearing from the judge why it's risky for you to go to trial, all the weaknesses of your case, and what is actually a reasonable settlement offer is a lot different from hearing that from your attorney. So that sometimes carries some more weight, and it can convince parties to be more reasonable about settlement. Finally, even if the case doesn't settle in the pretrial settlement conference, because it's usually only a 1 to 3 hour process, if the parties can't actually conclude a settlement, it moves the ball forward on settlement and makes it easier for the attorneys to settle the case after the settlement conference, because both sides know each other's positions. You've had that chance to kind of flesh out where you stand on settlement, and it makes it easier for the attorneys to close the gap later on. So let's finally talk about the differences between a pretrial settlement conference and a mediation. In both a pretrial settlement conference and a mediation, you have a third party trained to facilitate the settlement of a case. In a settlement conference, it's the judge. In a mediation, it's usually a retired judge or a lawyer that's trained as a mediator. The big difference is that you pay the mediator. You don't have to pay the judge, but you have to pay the mediator for their time. So there's an extra expense with mediation. Mediations can go a lot longer than pretrial settlement conferences. They're not constrained by the judge's court schedule. So the mediator will spend as much time on the case as necessary in order to reach a settlement. And the mediator can also tend to be a lot more creative and flexible in the way that settlements are structured. If we're just talking dollars, then there's not a big difference. But if we're talking about sale of real estate or something that one party actually has to do other than pay money, the mediator can help structure a more creative settlement than the judge is usually willing to do. For that reason, because it's a bigger process, it's more expensive, we usually try pretrial settlement first to see if we can get the judge to settle the case.